operating a motor vehicle in a public place, that you committed the Class A misdemeanor of driving while intoxicated with alcohol concentration level of 0.15 or more.
This case begins with Ty DeMarcus Thompson standing before a Texas judge, charged with driving while intoxicated with a blood alcohol concentration nearly double the legal limit, 0.15 or higher. Right from the start, the stakes are high. A Class A misdemeanor can mean serious jail time, steep fines, and a criminal record that follows you for life. But pay close attention, because almost immediately, the prosecution drops the severity of the charge, reducing it to a Class B misdemeanor. But that decision will shape everything that follows. Thompson admits guilt early, but what's fascinating here is how quickly the legal gears turn: plea deals, waived rights, and detailed financial obligations all laid out in rapid fire. This isn't just about drinking and driving. It's about the weight of the legal system pressing down on a single individual. Stay with me, because as the judge unpacks the probation terms, the fines, and the community service requirements, you'll see how a courtroom takes what seems like a straightforward DWI and turns it into a life-altering 18-month probation sentence. The question is this punishment tough enough to prevent another incident, or just a temporary fix?
This is cause number 25CCCR 0460. Case is styled the state of Texas versus Ty DeMarcus Thompson. Mr. Thompson, is that your full name?
Yes, sir.
Mr. Thompson, would you please raise your right hand? Mr. Thompson, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Thompson, you may put your hand down. How are you doing, Mr. Thompson?
I'm doing good, yourself.
I'm doing fine. Thanks for asking. Mr. Thompson, you are represented in your case by your attorney, Attorney James Macon. Attorney Macon, do you waive a record in Mr. Thompson's case?
Yes, Sean.
Mr. Thompson, I have before me a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Ty DeMarcus Thompson, on or about November 28th of 2024, while you were in Jefferson County, Texas, operating a motor vehicle in a public place, that you committed the Class A misdemeanor of driving while intoxicated with alcohol concentration level of 0.15 or more. State, are you abandoning the enhancement paragraph?
That's correct, Your Honor.
This is a pivotal moment. The state abandons the enhancement paragraph. In plain English, that means Thompson avoids a Class A misdemeanor and instead faces a Class B, a softer charge with lighter penalties. For viewers, this is the kind of moment that sparks debate. Should someone blowing a 0.15, nearly twice the legal limit, really get a reduction? Prosecutors often make these moves to save time and ensure a guilty plea, but it raises tough questions about accountability. What do you think? Should prosecutors push harder for harsher penalties, or is efficiency in the courtroom worth the trade?
Mr. Thompson, the state is abandoning the enhancement paragraph, and what that means is, instead of being charged with a Class A misdemeanor DWI, you'll be charged with a Class B misdemeanor DWI, which is a lesser included offense. Mr. Thompson, to the Class B misdemeanor offense of driving while intoxicated with an alcohol the Class B misdemeanor offense of driving while intoxicated while you were operating a motor vehicle in a public place on November 28, 2024, how do you plead guilty?
Here, Thompson officially pleads guilty. But notice how the judge carefully walks him through every document, every signature, and every waiver of rights. This isn't just formality, it's legal protection. If Thompson later tried to appeal, these records show he knew exactly what he was signing away. For anyone watching who's never seen this process, it's a reminder: guilty pleas come with finality. Once you sign that paper, once you say those words, "Yes, sir, I'm guilty," the legal system locks into place like a machine.
Not guilty or no contest?
Guilty.
Guilty. Are you pleading guilty freely and voluntarily?
Yes, sir.
And are you pleading guilty because you are guilty? Mr. Thompson, I also have before me on my tablet a document that is titled Misdemeanor Plea Admonishment. This document is also labeled as State's Exhibit Number 1. Do you recognize this document? On page 2 of this same document, there are a set of initials, or two sets of initials. One set is your initials of your attorney. The other set of initials, TT, are your initials. Did you place your initials on this document?
Yes, sir.
On page 3 of this same document, there's a signature above the line that's titled Defendant. Is this your signature?
Yes, sir.
And on the next document that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
At the top of this document, there are two boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes.
Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes.
I also have a document that is titled Discovery Certification. Do you recognize this document? Is this your signature on the line that's titled Defendant?
Yes, sir.
Now, Mr. Thompson, before you sign and initial all of these documents, did your attorney, Mr. Macon, go over these documents with you?
Yes, sir.
Did you understand everything that your attorney went over?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Jefferson.
Mr. Thompson, are you a citizen of the United States?
Yes, sir.
Jefferson.
Any objections, Mr. Macon?
No.
No objections? State's Exhibit Number 1 is admitted. Mr. Macon, you advised and counsel Mr. Thompson. Is there any evidence that he is currently mentally incompetent to stand trial?
No.
And Mr. Thompson, your attorney, Mr. Macon, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Mr. Macon, Mr. Thompson, I will accept your plea of your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
The judge accepts the guilty plea and declares Thompson competent to stand trial. But here's the key line. I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. Even though Thompson pled guilty, the judge still has to ensure the evidence holds up. This safeguard exists so that people can't be wrongfully convicted on a weak or fabricated case, even if they admit guilt. It's one of those subtle but critical checks in the system that shows the law isn't just about punishment. It's about procedure, fairness, and record-keeping.
The agreement in this case is 180 days prorated over 18 months with a $1,000 fine, 80 hours community service, the installation and maintaining of an interlock device, and GWI standard conditions of probation. This probation is running concurrent with 24 CCCR 1272.
Okay, let's see. What's the court cost?
$392.
Three.
Yes, sir.
What's that? So, Joe's on.
Okay,
Now we hear the deal: 180 days in jail, probated for 18 months, plus a $1,000 fine, community service, and an ignition interlock device. This is a classic Texas plea deal for a first DWI. But let's be real, probation isn't a free pass. For the next year and a half, Thompson will live under strict supervision. Any slip-up, missed payment, failed alcohol test, skipped service hours, could mean serving that 180-day jail sentence in full. It's like walking on a legal tightrope.
Mr. Thompson,
Yes, sir.
the state is offering that you serve 180 days in the Jefferson County Jail, but you will not serve any time in the Jefferson County Jail because you'll be on probation for a period of 18 months. During the 18-month probationary period, you'll be required to pay a fine of $1,000 plus court costs of $392. You will also be required to pay a Jefferson County, you'll be required to pay a DWI conviction fine fee of $100. You'll be required to pay a reimbursement fee of $15. You will not be required to pay probation fee of $60 a month because you'll be paying that in the other case. And you will not be required to pay the urinalysis fee in this case because you will be paying that in the other case that you receive probation on. Now, your total monthly installments, that is the total amount that you will be required to pay each month, is $89 a month.
Yes,
Will
sir.
you be able to pay the $89 each month?
Yes, sir.
You'll also be required to perform 80 hours of community service. You'll be required to install an interlock device on any vehicle that you own or operate, attend a completed day-to-day education class, have an alcohol assessment, and adhere to the other standard terms and conditions of this probation. And this case will run concurrent with cause number 24CCCR 1272.
This section is where the financial and personal cost becomes crystal clear. Monthly payments, mandatory classes, alcohol assessments, and even the interlock device, which prevents his car from starting if alcohol is detected on his breath. These aren't just penalties, they're reminders every single day of the consequences of one bad decision. The judge lays it out with precision: $89 per month, 80 hours of service, and compliance with every condition. Ask yourself, is this enough to change behavior? Or is this just bureaucracy disguised as justice?
Mr. Thompson, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer is fair and just?
Yes, sir.
Do you accept the state's offer?
Yes, sir.
Mr. Thompson, I'll follow the plea bargain agreement that you have entered into with the state. Now, Mr. Thompson, you're going to stand at the end of that table, follow the directions of the bailiff. Once you're finished following the directions of the bailiff, you'll be free to go, and you have a blessed day.
All right, thank you.
And Mr. Macon, you'll be free to go as well, and you have a blessed day.
Thank you.
Okay.
And just like that, the case is closed. Thompson walks out with probation instead of jail, but the real weight is on his shoulders, financially, personally, and legally, for the next 18 months. This case illustrates the balancing act courts face: punishment versus rehabilitation. On one hand, the state avoided a costly trial. On the other, a driver who was nearly double the legal limit walks away without jail time. What do you think? Was this justice served, or was this a light sentence for a dangerous offense? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.